Under California law, employees and would-be employees that fall within protected classes as defined by statute are protected from illegal discrimination by employers or would-be employers. This basically means that the employer cannot take an adverse employment action against the employee or would-be employee based on his or her membership in a protected class. Protected classes under California law include race, color, religion, including religious dress and grooming practices, sex or gender, including pregnancy, childbirth, breastfeeding, or other related medical conditions, gender identity or expression, sexual orientation, marital status, medical condition, military or veteran status, national origin or ancestry, disability, genetic information, or based on an employee's request for family care leave, request for leave for an employee's own serious health condition, request for pregnancy disability leave, or age where the employee is 40 or over. All of these are considered protected classes. The main categories of adverse employment actions that are prohibited by law for members of protected classes include a refusal to hire or employ, discharge or termination of the employee, discrimination against the employee in terms of compensation or other terms, conditions, or privileges of employment. In order to prevail under California law for an employment discrimination matter, the plaintiff, employee, or would-be employee must prove that he or she was subjected to an adverse employment action. Adverse employment actions are not limited to ultimate actions such as termination or demotion. There is an adverse employment action if the employer has taken an action or engaged in a course or pattern of conduct that, taken as a whole, materially and adversely affected the terms, conditions, or privileges of the plaintiff's employment. An adverse employment action includes conduct that is reasonably likely to impair a reasonable employee's job performance or prospects for advancement or promotion. That being said, minor or trivial actions or conduct that is not reasonably likely to do more than anger or upset an employee cannot constitute an adverse employment action. As one court explained, quote, "Not every change in the conditions of employment, however, constitutes an adverse employment action. A change that is merely contrary to the employee's interests or not to the employee's liking is insufficient. Workplaces are rarely idyllic retreats, and the mere fact that an employee is displeased by an employer's act or omission does not elevate that act or omission to the level of a materially adverse employment action." Another court observed that the reduction of a plaintiff's hours alone could constitute a material and adverse employment action by the defendant. Also, a different court found that a job reassignment may be an adverse employment action when it entails materially adverse consequences. But in order to be successful, the plaintiff employee or would-be employee must demonstrate that a substantial motivating reason for the adverse employment action was his or her membership in a protected class. One court explained it as follows, quote, "While a complainant need not prove that discriminatory animus was the sole motivation behind the challenged action, he must prove by a preponderance of the evidence that there was a causal connection between the employee's protected status and the adverse employment decision." California's standard jury instructions on employment discrimination are helpful to help us better understand how this whole thing works. So let's run through that. The plaintiff claims that the defendant wrongfully discriminated against him or her. To establish the claim, the plaintiff must prove all of the following. 1, that the defendant was an employer. 2, that the plaintiff was either an employee or had applied for a job with the defendant. 3, that the defendant either discharged or refused to hire the plaintiff, or that the defendant subjected the plaintiff to an, quote, adverse employment action, end quote. 4, that plaintiff's protected status, membership in a protected class, was a substantial motivating reason for defendant's decision to either discharge, refuse to hire, or take other adverse employment action. 5, that plaintiff was harmed. And 6, that defendant's conduct was a substantial factor in causing plaintiff to be harmed. One court explains this type of basic discrimination as follows, quote, conceptually, the theory of disparate treatment is the most easily understood type of discrimination. The employer simply treats some people less favorably than others because of their race, color, religion, sex, or national origin, end quote. California law provides that the statute of limitations for employment discrimination cases is 3 years from the date the alleged discriminatory act occurred. That is the general rule, and it basically means that if the claim occurred more than 3 years prior to the date of the filing of the lawsuit, there will be a defense based on statute of limitations. As with most things in the law, these cases are extremely fact-intensive and fact-driven. Every case is different. So if you believe that you may have a claim against an employer, it is imperative that you take prompt action to consult with a qualified labor and employment attorney and get their opinion. Needless to say, this recording is intended merely for educational purposes and should not be relied upon as legal advice or solicitation to be employed as your counsel. That being said, if you believe you have a claim, you may contact us at Benjy Law Corporation for a free consultation. You can reach us at 310-203-2650, and we also invite you to check out our website for more resources at www.benjylaw.com. That's www.benjylaw.com. Thanks for listening.